started. Okay, we'll call to order the April 15th, 2025 meeting of the Utah County Planning Commission. And first is our Pledge of Allegiance. Chris, would you like to lead? Okay, let's do that.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. First order of business is our minutes from March 18th. Do we have any changes to those minutes or a motion regarding the minutes?
Motion to approve?
We have a motion to approve. Is there a second?
I'll second that.
All in favor?
Aye.
Aye.
Aye. Okay, minutes are approved. We have a public hearing tonight, and we'll open that public hearing after we take a vote on that. The item is a proposed Utah County Land Use Ordinance text amendment to chapters 8 and 16 and any other applicable sections. Do we have a presentation?
Yes, I'll take care of that. It's Bryce Armstrong, Community Development. If you recall, about a year ago, staff reviewed our designation for the Board of Adjustment as a land use authority. We were kind of an oddball in the state where we had our Board of Adjustment hearing our conditional uses, which is a administrative land use decision. And so we went through an effort to amend our ordinance to migrate those conditional uses over to this board, the Planning Commission, which left the Board of Adjustment as solely as an appeal authority, hearing alleged errors, appeals of a decision, that administrative decision that's been made, and also variances, which is also a type of appeal to ask for relief from a standard in the ordinance. So tonight we're looking at specifically the appeal authority role of the Board of Adjustment. Staff has worked with the attorney's office, and we feel that kind of best practice would dictate that we create an opportunity or a provision in the ordinance that would allow a designation of an administrative law judge. Is that what it's called? Mm-hmm. Administrative law judge to act as the appeal authority. The idea is this person would be an attorney licensed in the state of Utah and is familiar with land use matters. The appeal authority and the types of appeals that go before the appeal authority are kind of a quasi-judicial matter. And so it's helpful to have someone who's maybe a little more versed in law, land use law, than our citizens. Citizens do great, but especially with our Board of Adjustment, we only convene now that they don't have conditional uses under their purview once a year, twice a year. And so we try and train them so they're prepared for these type of appeals, but you don't act on it for a year. It's kind of hard to remember that. So all that being said, we thought maybe it'd be best practice, which is also common around the state, to have this type of provision in the ordinance that would allow this position to act as the appeal authority to hear these matters. So what I'll do is run through some of the red lines. There's quite a bit in there, but a lot of them are just kind of reorganization and housekeeping. But I'll try and hit the main ideas. We've got our attorney's office. Brittany Thordley has helped us a lot with this, and she can and Dale can kind of help answer some of any legal questions and kind of the thinking behind all of that. Okay, so there are several sections of the ordinance that were affected. Chapter 8 was affected just due to notification. I might add we also went in and did some general housekeeping that aren't specifically related to this effort, but since we were in there, we kind of wanted to address everything that we could at this time. So the first section there, 8.04, this deals with notification requirements. Certain types of applications require certain types of notification as per state law. And so previously, we identified all the different types of matters that may require notice, and then generally just referred to state code. So rather than be redundant, we just are going to refer to all notification just be required to meet state code as amended, and not worry about spelling out each separate use, but just defer to state code. We've tried to do that as much as possible elsewhere in the ordinance, so we're just trying to be consistent there. The only other item I would mention here is specific to the appeal authority. I mentioned the appeal authority hears variance requests, and so previously our ordinance required that we send property notices to adjacent property owners that were adjacent to someone who was requesting a variance. That was above what state law required. Kind of trying to be consistent with state law. Could be sometimes problematic with bringing people to a meeting where they maybe feel like there's something that they can input into the decision. These are again quasi judicial, really. Straight on the law, and so we felt that it's probably best to just follow state code on that. And so we eliminated the variance applications from receiving adjacent property notice. Good there? Okay. And then this gets into Chapter 16, our kind of meat of this provision. This first part is just, so I want to back up. We're not eliminating our Board of Adjustment. We felt that it's a good option to have if the commission chose to, hey, we don't really aren't happy with our ALJ or whatever, or we feel the Board of Adjustment's a better option. So we wanted to leave that in the ordinance as an option. So a lot of this was just kind of restating some provisions that were already there, and that's kind of what these first sections are. Just kind of clarifying between a meeting and a hearing. These are truly hearings where these are appeals. Again, these are more just restating or clarifying what was already in the ordinance. We get down to 1641. This is where we're inserting the provision for a land use administrative law judge to be created. And so our attorney's office helped draft this language to create an ALJ, and as I noticed, or as I mentioned earlier, subsection D kind of indicates some of those qualifications. I'll just skim through those, and then I'll maybe take some questions when we get to the end here. 1644 is just our rules and procedures. Already had these in place for the appeal authority. We're just kind of clarifying these and restating them. Pretty much the rest of this is clarification. 1648 is more just clarification and just referring more to state code again rather than restating that. That's helpful when state code gets amended. We don't have to go in and always amend our ordinance. Let me just get to a couple changes that you may have some interest in, and then I'll entertain any questions you have. One thing that we did that you will find of interest, I'll make sure I'm not missing anything that was too much of a change. Again, these are all the different types of appeals they hear and the procedures for those applications. So, reference to state code there. These are variance requests that we used to spell out basically verbatim what state code required, so we just refer to state code. One thing that has changed here is similar to the conditional uses, and I'll touch on that in a second. When a variance is approved, it has a duration of approval. previously the ordinance kind of treated it like the conditional uses where the initial approval was 1 year, but the appeal authority could set a different time period at the meeting. And then after the meeting, an applicant had the ability to come back and ask for an extension. Those of you that were here last month, that'll sound familiar. And so we felt that we needed to rein that in a little bit. And so specifically for variances, it still allows someone at the meeting to say, hey, this is a really unique situation. We're going to need more than the 1 year. And that justification can be heard and determined at the meeting that the variance is being heard. After the meeting, or after the hearing, there is still an opportunity to enlarge that time period, which is generally 1 year. But this extension, this additional request, we have limited it to a one-time request up to 1 year. Now, this is just for variances. Variances are a very different animal than conditional uses. And so we felt that, if you can't get that within a year, then it probably needs to be reheard if you want to or someone wants to pursue that. And I'll get to the conditional use side of that change here in a second. Make sure we didn't miss anything else. 1688 deals with the procedure to appeal the appeal authority. Just following state code there. And 1694 is the part that deals with conditional uses, which will affect this group. Similar to what we were just talking about, if you recall, the present ordinance, let me get down to it here, allows someone to, when they get their approval, the time to obtain a permit is 1 year, but that can be enlarged at the meeting if for just cause. And then after the meeting, there was no limit to someone coming back and asking for extensions. And we've seen that quite often, not just with the applicant last month, but some of our large solar farms. They've got certain processes they have to go through, and part of that is getting the local authority to approval first. And so then they've got to follow up with a bunch of other steps. And so there is justification for these extensions. We recognize that. But we just felt like we needed to put in some limits. And so similar to the variance limits, it still allows someone to make their case at the meeting and have upfront saying we know we're going to need more than 1 year, but now it's actually 3 years to obtain our permit, and this is why, and then the planning commission can determine that at that time. The default we've changed from 1 to 3 years. So if someone comes in, asks for a conditional use, and they don't ask for any additional time, then they have 3 years to get their permit rather than 1 year. And then relative to coming in after the meeting, we're allowing someone to come in one time for an extension request of up to 5 years. We feel kind of what we've seen and with other applicants that should probably be enough. If someone knows there's going to be a challenge up front, then they can make that at the original hearing, get some additional time then. They still have that ability to come in and ask for an additional 5 years. But we wanted to put some caps onto that. So, okay, I blew through a lot of stuff there.
Ready for questions?
Yeah.
Okay, well, now that our chair is here, turn back to the chair.
Is there questions from the commission?
Just my understanding on the variance is just a 1 year time period if there's conditions for that variance, right? Because the variance runs with the property, doesn't it? I mean, like if you're, or is my understanding of what a variance does wrong?
Yes, it does. So a lot of times a variance will be utilizing a structure or use that's already present. So the time frame is that doesn't apply. But if someone's coming in and saying, I want to build this structure and I want to build it 1 foot from the property line where 15 is required, and they get that approval, then they have a certain time limit to get that permit for a new use.
Okay.
But you're right.
But if they have 99 feet to build a home, you give them a variance. I mean, they're not going to have to tear down the home in a year or anything like that, right?
No.
Or frontage.
No, I mean, this is pursuant to a permit to utilize that permit if this is a new use.
Okay.
I have a couple questions.
Yes.
So in here it says that there's an administrative law judge that will be appointed. Appointed could mean two different things. Are we talking about a volunteer position or a paid position with the county?
So this, I'll let the attorney's office speak a little more to this, but this will be someone that the county will enter into a contract with, and they'll be paid to serve in that role.
Okay, so we're sending,
Still appointed by the commission, county commission.
right, but they're an administrative law judge that's appointed by the commission, but they're supposed to be impartial, but they're employed by the entity that is part of this process of appeal. Is there a conflict within that? It seems like
There is
there would
not.
be.
No, there is not.
Okay,
They're not employees, they're independent contractors. They sign a contract with us, the contract requires them to be impartial and unbiased.
the renewal of that contract is also from the commission?
Yes, they entered into that contract with Utah County through the county commission, yeah. And if they don't follow their contractual terms, they can be terminated and another ALJ. This is fairly common in government. Just hasn't been here for some reason, I don't know why. We expect ALJs to be used throughout the county in other capacities too. It's just something we're starting here. The other counties already do it, but it's something that we're trying to initiate here. As far as I know, this will be the first time we're the guinea pigs, which is okay. It needs to start somewhere, and this seemed like a good place
For Utah County.
for Utah
Utah
County.
County.
And-
Well, sorry, one other question. What does the state code say as far as the form, function, and requirement for a board of adjustment? Does it require that they exist or have specific duties, or is that just a thing that we've done in the past?
Brittany Thorley, Utah County Attorney's Office. So the state code just says that there needs to be an appeal authority formed, and it can take the form of a panel like we've had, or it can be an administrative law judge in the ALJ.
Okay,
So it's both are permitted by state code.
you can choose either or both,
Yep.
however
Yep.
works. Okay,
And the county commission will actually make that decision, probably on a yearly basis, as they allocate budget funds for either a BOA or a ALJ. And it could change. Some commissions may feel like they want an entire board to hear something, and some may feel that an ALJ is more efficient and effective.
I did just want to comment too on your last question. If you're concerned about undue influence of the Board of the Appeal Authority generally, it really takes the same form because the Board of Adjustment has been appointed by the commission as well. And so this is just a separate appointment process.
sure. The only difference I can really see is compensation, where a board of adjustment is
Oh,
not
okay.
compensated.
Yes.
Although a BOA could be compensated if we chose to.
Well, where's that been?
Yeah.
We give them $20 a meeting.
We need to form a union.
Hey, that was struck down this year. Spencer Cox.
Yeah, but they're gathering signatures.
Very true.
So a question I have, is it common that they'll serve for an indefinite time? Sometimes in my mind, hey, you serve indefinitely, then there tends to be, if there's some issues, I mean, how does one?
Are you talking about the ALJ?
Correct, yes.
ALJ will be a contract term, 1 year, 2 years, 3 years, whatever the contract is. And of course, there will be a termination clause. The county commission can terminate it. They can also choose not to fund. Everything that happens in the county has a funding provision, and if it's not funded the next year, it doesn't happen. So no, it's not indefinite.
Because, I mean, that's what it says in B, it shall serve for an indefinite time at the pleasure of the county commission and may be released with or without cause. So,
Yeah, that's the way we would draft the contract, yeah.
okay.
And just for more context on that too, it is possible, the way this is written, to appoint more than one ALJ at a certain time, just so that there's, I mean, same with this group, right? So if someone cannot come to a certain meeting, there's sort of backup. And that's also at the discretion of the commission, but only one ALJ would ever hear one hearing at a time.
That's a good point. There can be conflicts with ALJs. You know, if they take a case and they were involved in it as a private attorney, they can't hear that case. So there would be backup ALJs with contracts.
Any other questions? I kind of missed the initial introduction to the topic. Is it, we're doing this to try and adhere to state code? Is that basically?
Not necessarily, more kind of best practice. The types of matters that come before the appeal authority are quasi judicial matters and really need to follow state law. And when you get a board of citizens, we found in the past that sometimes, you know, there's sympathy involved and, well, that doesn't make sense. You know, that's, you should get that. And so, and we've had several of those decisions and they can be, they can open up the county to some liability for sure. And so we want to kind of maybe ensure that we're getting, you know, the law followed in these type of appeals and more consistency with the law.
And we picked up some of the duties of from that group, right?
The conditional uses.
Conditional use we picked up from them.
Which are not these quasi judicial appeal type of uses. That's more of a administrative land use decision. And I don't know if you heard this part, but we were only getting maybe one meeting a year at the Board of Adjustment, and you know, it's hard for them to remember what their duties are, their roles are when you're just meeting that infrequently.
We also had an interesting comment from Commissioner Beltran, who sat on that board, and he was in favor of an ALJ. He just felt like the nature of the business before the board and how he had seen those meetings run, he felt that an administrative law judge would probably be better. That was kind of the tipping point. We knew this was best practices for several years, thinking about it, wanted to do it, and then he kind of said, "Yeah, you need to do that." I said, okay, let's see how this
Oh, then
works.
I'm voting against it if Skylar wants it.
These decisions of the appeal authority, if those decisions are appealed, that goes straight to district court, and we've had those appealed quite often, and so, you know, there's some liability to the county.
What's been the resolution when they've been appealed? Is it generally something that goes in favor with what the Board of Adjustment had decided, or does it tend to go the other direction, or is it just all over the place?
My experience has been they didn't follow the law, and the applicant knew it, and so they appealed it, and then the court would remand it back to the Board of Adjustment.
I have a question. So is the vetting process, is it hard? I mean, how much energy has to get put into vetting the person who's going to be that on the contract?
I feel like it's pretty good. I mean, the attorney's office, of course, looks at all of them, make sure it's someone that we've watched practice, that's responsible, has a good reputation, does good work. Of course, then they go to the county commission and they do their own investigation and decide if it's someone they can trust. It's contractual. If we find out they're not doing a good job, we terminate the contract, get someone else. In other areas, they found it to be very helpful because, like Bryce said, if these appeals are denied and they go right to district court, we've already had a lawyer look at it. And so, and we're going to have a lawyer look at it in district court, and the district judge. So it tends to be that the issues are narrowed and they're limited to legal issues, rather than getting into trouble with any politics or persuasion or clamor or anything like that. We don't see that with an ALJ decision. It'll be more a very narrow legal issue that maybe they got wrong and now a judge needs to overturn it. But it's less likely in that case.
Back to we picked up some of the duties from the Board of Adjustments here, but did we vote on that at some point, that we would pick those up?
You did.
We did. I was trying to remember.
I think it was unanimous.
And so this fall, even though these changes fall to us to recommend to the commission?
This is, yeah, what we're dealing with here and what we dealt with there was an amendment to the land use ordinance on how we apply the ordinance. And so those by state law require to receive a recommendation from the planning commission.
Any other questions, commissioners? We already did what?
No, we need to.
We're
We
in a
need
public
to have a
hearing.
public hearing. We haven't opened it yet.
Afterwards, so sorry. No
Okay.
further questions.
Do we need to open
You
a
ready?
public?
Yeah.
Yeah, you need to make, have a motion, entertain a motion and vote on opening public hearing.
Are we ready to open a public hearing? Anyone?
I move that we open the public hearing.
Second.
Okay, it's been moved and seconded to open the public hearing, and we'll start down here with Commissioner Harrod on a vote.
Aye.
Yes.
Yes.
Yes,
Yes.
Yes. Yes.
we're now in a public hearing. Is there anyone that would like to address the commission in the public hearing? Okay.
It's kind of weird.
Now's
We
your
don't have
time to
like
speak.
a second side on this thing, 'cause usually it's the applicant and it's the
Yeah.
staff. There's nobody.
Okay, so if there is no other questions, is there a motion to entertain on this?
I would make a motion to recommend approval to the Utah County Commission as listed under Section 4 of the staff recommendations.
Second,
That's section 4.
page
I
3,
think I
like right by
found
your
it. I
blue
think I found
thing.
it, yeah. Okay, we've got a motion to approve as it's been recommended under section 4 of the staff recommendations. Is there any further discussion to the motion that's on the table? Okay, then we'll have a vote. We'll start down on this end.
Yes.
Yes. Yes.
Yes,
Yes.
Aye.
Yes.
we've got a recommendation for the county commission.
Just as a matter of housekeeping, probably want to close
Close the public hearing.
I move that we close the public hearing.
Second.
Moved and seconded to close the public hearing. And we'll start again down here.
Yes.
Yes. Yes.
Yes.
Yes.
Yes.
Yes.
Okay, the public hearing is now closed, and other business.
So yes, we didn't want you guys to make an effort to come out tonight and just only be here for a few minutes, so we're going to keep you longer. State law requires that we do training every
Nice.
year, annual training. I know a lot of you have been to some of the outside trainings that we've had, which have been great, but we're going to have our attorney's office give us some open meetings training and also some general duty planning commission trainings. This is his baby, but I believe we've brought some sandwiches over in the other room, and so
I highly recommend you go get something, just anything,
Before we start.
before we start.
Oh, come on.
You should eat while I talk.
How
Then you can
long
sleep.
I kind of wish that I had known that before.
As long as
As
the
fast as possible, I promise you.
training
We're not
timer
trying to
has
outdo
started,
last
then
time,
we
right?
can feel free to go get food.
Yes, go
but-
right ahead,
Oh, I know, you guys.
please. If we start an hour, we get an hour's credit, so we're already an hour
an
into
hour,
this,
okay.
I got some pretty good support for it. Let's do this one first. Okay, there you go, yeah.
No, I think your question was good if there's conflict, but I would argue
easy on us. At all.
And just
Is
one
there
more
a
comment.
playback speed button that we can?
1.5, 2, something. This guy just needs to speak faster. I will just want to mention on the business that you conducted today, that we needed you to do that this month. We've kind of been operating in a twilight zone. We could have an appeal next month, and so we're already 4 months in the year, so we needed you to do that. Appreciate your time and attention to it, so we can move that on to county commission. You should have received this training every year you're here. And so this won't be new to some of you, but what I've learned in government is it's often overlooked. I got a call 3 Mondays ago from a county employee who sits on another board, and he said, "Are you going to be at the board meeting tomorrow morning?" And I said, "Well, it's not on my calendar. I wasn't planning on it." And I said, "I don't think you want to have a meeting tomorrow." He said, "Well, why is that?" He says, "Because it wasn't noticed up. It's an open public meeting, and you have to notice those, or you can't." He had just completely just spaced that off, because I think other people do it for him. But it let me know that this is something we need to train regularly and keep in people's minds. That, well, let's get into it, because you'll see why. Why do we have OPMA, the Open Meetings Act? It's really an easy question. It's all about government transparency. We do everything in open public meetings, and every public body should be doing their business in an open public meeting, and that's really what the statute is and says. And why we forget that sometimes, I'm not sure, but the presumption is every meeting is open to the public unless closed. That's what we start with. That's what should be in everyone's mind when you sit on one of these boards or you become an elected official, especially when you become an elected official. That should be in your mind. Am I sitting in a meeting that should be open, that the public should be here, that should be recorded? We want that to be the default for people in government, that can I legally be doing this? It's always a good question. And, when you get into this, it really becomes second nature. County commissioners, they think about it all the time. When they walk into a room, they look around the room, and if they see another commissioner, they're thinking open meeting, which is what we want them to do. It's a sunshine law. It's all about making sure the government's work is done in public so that, so it can be tested by the public, whether, those are the people that are going to call us out if we're doing something wrong. So we do everything in public. Let's go on. And by the way, right there at the end of that slide, you'll see that statutorily you're required to have this training annually. So what you're here, you're earning your money today, because you can't operate unless we have this training. So we have to do it.
There's money?
Yeah, you're eating it. A few definitions. This is more important to lawyers usually, but it does come up. In fact, we're having a meeting of a county body tomorrow, and one of the first questions was, is it an open meeting? Is it a public body? It's an employment type hearing, so turns out it is. So there's a definition of public body, so you can identify what government bodies need to have open meetings. We follow the definition completely. We look at all of those elements to make sure. I won't bother you with those, but you're clearly covered as an advisory board to the county commission. So our meetings have to be open. You're clearly a public body. There's no question about that. A quorum is necessary. We look at the definition of quorum because unless you have a quorum under the statute, you cannot convene or do any business. And that's why you see the flurry of emails before every meeting. Will we have enough members here? Because that is a statutory requirement. If you don't have enough, you can't convene the meeting, and you clearly cannot do any business. So it's important. What is a meeting? Now, this isn't really important to you guys. You guys know when you're in a meeting. But it could be important if 4 of you, which is a quorum, were to meet somewhere outside this meeting. And heaven forbid, start talking about something on the agenda or something before you. You know, at that point, you should be thinking, are we holding a planning commission meeting right here? Are we doing something wrong? That's what we want to be going off in your head, those red flags. You know, first of all, I am a member of a public body. The Utah Planning Commission is. So right there, you know. Are there more than 4 members present in this meeting, wherever it is? Parking lot, you know, BYU Stadium, wherever. Is there more than 4? I should be thinking, are we doing anything wrong? And then they've changed the definition of meeting, which hasn't been tested yet, but I feel like it's going to help us. And what I mean by that is, see, if 4 of you are up at Cougar Stadium in a ball game and start talking about something before this board, you're a public body and you're a quorum, so you've meet the first 2. But the question is, are you in a meeting that's been convened legally? This is new, okay? This hasn't been tested. We have no case law on it, but it feels right. That meeting at Cougar Stadium is not a meeting because it was not convened by Shane, the chairman, following lawful process, which is notice, for the express purpose of acting as the board. So it's probably not going to be a meeting. The reason I think this is helpful is that did not exist before, so that anytime 4 or more members of your board would be together anywhere, there would be a question whether it's a public meeting, and you'd call up the attorney's office and say, hey, we have a problem here. You'd be surprised how often this comes up, especially for elected officials. You know, they're sitting at UAC meetings in St. George, or worse, a budget retreat somewhere in southern Utah, and all of a sudden, oh, there's too many of us here.
Especially for a 3-commission.
3 commission is maybe one of the worst inventions in government. 5 would be much better, but I don't want to get on that soapbox, not tonight. So we do have a definition of a meeting. It is fairly narrow. I like that. So what does OPMA require? Here's the thing just to keep in your mind. Our meetings must be open unless they're closed. And we will talk about closed meetings. Don't anticipate you having any. Here's something you don't do, but we do, Marie does, record all meetings and prepare minutes. As a public body, that must exist somewhere. The public has to be able to review your meetings and look at your minutes. The next one, predetermined actions, that is new this year. And that is why I feel like they've covered the whole meeting problem. We'll get to that in the next slide. Notice. Notice is critical to open meetings. If the public doesn't know when and where you're meeting, they can't be there. They can't speak, they can't comment, they can't watch, they can't report. And so notice is clearly required for public bodies and having notice. And then, of course, we hit again the training annually. So we like to repeat that just so you know we aren't intentionally torturing you with this information. It's actually necessary. Okay, so this is new.
Are we allowed to ask questions?
You can ask any question you want.
Okay, so the notice is funny because I feel like the general public, they don't know where to go. So it's sort of like you kind of have the check mark box, we notified, but people don't seem to really be still informed. So how, I mean, it still seems a little disingenuous to say, well, we notified, but if nobody knows what to look for.
Okay, we have a notice slide, and I think I'll get into that a little bit more, but it's designed the best we can to give notice. You know, if we had billboards, it would be better. But we have a public notice website, and then we have the county website. And what we've learned is people learn where to go. People who care enough to want to know about meetings, they know where to go. So it is effective for those who care. Now, as far as publicity, marketing, trying to publicize it, yeah, it doesn't work that way. But as far as a legal requirement of notice, it does work that for that.
It wasn't too long ago where you were looking in the classifieds, the legal notices for this tiny print. I mean, the state's really made an effort to say, there's one place you can go where all the public meetings will be noticed. You can you can get alerts for meetings that you have interest in. And so I think there's recognition of that they're trying to address.
It's better than it's been. Is there another question? Okay, so this is the one you want to look at that might trip you up. So the concern that we've always had with open meetings is, are members of the body doing business outside of the public meeting? Now, this could come up in texts. We have case law where officials are texting during a meeting, and so their comments aren't going out to the public, and that was considered a meeting. You had an illegal meeting over your text messages, and rightfully so. They were conducting business by text where no one could see it and no one could hear it. And so we've had this problem, and it comes up in different ways. We want to make sure that decisions about the public business are not done secretly. So when they changed meetings, they added this, and they said, we're going to use this to try and control these secret meetings. If a quorum of members of a public body get together, coordinate, whatever you want to call it, in a concerted and deliberate way to predetermine an action. Now again, this has not been tested in court. We don't know exactly what all of this means, but we have a pretty good idea that if there's ever evidence, witnesses, text messages, emails, secret recordings of a quorum of a body, so 4 of you, getting together and deciding, we're going to vote this way, that would be an illegal, closed, secret meeting and would be voidable by a court. It's also punishable by a Class B misdemeanor, attorney's fees, so it is fairly serious. But that's where they went with this. And it hasn't been tested, but I'm okay with it. I think we can work with this. I think we can convey to you, please don't do this. Don't try to, cook the books and get together and grease wheels and make things happen outside of this meeting. And as you'll see here, this, our newest attorney added this, which I think was very good. Simply asking a member's inclination on a vote could constitute a violation. I agree with her, okay? This isn't tested. We don't know yet exactly where this is gonna go, but that feels fairly close to predetermining. I wanna know what you're doing, so I know what I'm doing. No, we don't want that. We actually want it to be all done right here, okay? And we're not talking about information gathering. We're not talking about you calling Marie or Bryce, say, I need more info on this. Can you send me more info? We're talking about voting, making decisions, predetermined actions. It could be the other way. It could be, I want to shut this down. Will you help me? Okay. So that's where we're going with, yeah.
So this seems to me one additional reason why we have to be very careful in our email conversations as far as responding back to an email that's been sent to all of us from staff saying, hey, the meeting's coming up. That's not a forum for us to ask questions about what's coming up on the meeting, to be careful there. But also, if we have somebody of the public who happens to get all of our email addresses and put us into a group, does that then constitute a meeting just by them sending that and make that a public record?
That would never happen.
Very good. No.
Okay.
Because we're gonna cover that tonight really quickly in an ex parte contact. We're gonna shut that down. We're not gonna let that happen to you. For instance, so the policy is right now, if we were to send you out something that you would be using in a meeting, we would blind copy all of you so that none of you could respond back to the other members or reply all to the other members with an answer. We've taken precautions to make sure that doesn't happen. We'll get information to you, but we're not gonna allow, just an email response to create a meeting or a predetermined action. Okay? Same with someone on the outside. When we talk about ex parte contacts, we won't want you to do anything with that. We kind of talked about that 2 meetings ago. You get something, the only response is, Marie, I've got this. Take this out of my hands. I'm not responding, I'm not sending, I'm not forwarding, just give it to her. Okay? Staff, we take care of that. So I think we'll avoid any kind of predetermined action because you'll simply shut down and say, we're not responding. We're not responding to the sender, we're not responding to each other, we're sending it to staff and they'll get it to us legally. Does that answer the question? Okay. And so if you get an email and it looks like it went to everyone, but you can only see you, that's what's happening. We're sending out a blind copy so that you get information, but you can't respond to everyone, so we don't have a quorum or a meeting or a predetermined action. Okay? Okay, notice requirements. There's the notice requirements. Lorraine, I totally get what you're saying. Due process is what we live by. But I also feel comfortable with these notice requirements in OPMA.
I think as having been the HOA president and in a pretty big community, and as well, I'm sort of the spokesperson. I send all the emails and notifications. It just seems like you're going to be able to prevent sort of a more clamorous meeting if people don't feel broadsided, right? And so I feel like there's, maybe there should be an extra effort for the county because a lot of people don't look. I mean, a lot of people have different ways that they're learning and getting information, right? And so I just think it behooves the county to maybe get on Instagram, and you probably are. I mean, it's just amazing how many people don't do Facebook, and then some people do Facebook. So it's a difficult thing. But it just seems like for you guys down the road, when you have a very, something that could cause a lot of contention, the more that people know about it ahead of time, it just seems like it would be less conflict.
Two comments. One, their attorneys, me being one of them, wouldn't allow it. When you undertake a legal duty, you also assume the responsibility and liability of doing it wrong or badly. So our advice usually is to the county, whatever department it is, please follow state law because there's safety in state law. And so we ask them not to do things like that. Now I can tell you the second comment is these folks are so good at telling people this. They get a phone call, they get an email, they get a person walking in. They're constantly telling them, hey, here's where you go, okay? You've got the Utah State website, you've got our county website, you've got message boards where we post it. It's there. And what I've noticed is the people who you see regularly at your meetings, they know exactly how to do this. And they also help tell other people. This is how you get this. This is how you find out. And it's actually working.
Don't you send out notifications, like, for example, if somebody's putting in something on one property, you notify the neighbors around that? Isn't that?
That's the conditional use permit notification that you just saw.
Yeah.
Yes.
So that is above and beyond state code. I
Right.
think we're trying to, for better or for worse, we're doing that. Rezones, someone's changing the zoning designation on their
Right.
specific property, state law requires that there's certain additional notifications for those
Because
also.
let's face it, some of the stuff that we deal with is pretty boring, and the general public doesn't care to be notified about it. But those who care to be notified, we take extra efforts to get particular people who might be impacted the most.
And so does state law. You'll notice that we removed 4 or 5 references to state law in the notice provision because state law already requires it. For instance, vacating a road. There's a lot of notice that's required to do that. We don't have to repeat it in the ordinance. State code does take care of people, yeah. So yeah, we do mail out a lot of notices. Now, not to your meetings necessarily, but there is a lot that go out.
And just one quick comment, we're going to be undertaking a pretty significant effort to update our general plan here in the near future. That's something that obviously has state noticing requirements that we'll meet. We'll also have open houses that will utilize those other mediums to get the word out, to have them participate in the open house. And then, they'll know it's on their radar, and then they can follow the official action items through the normal channels.
So you see under notice, there's go
I have
ahead.
a question. So I know so part of the notice is the agenda. And most of the time, the agenda is set by staff. Is that true for most meetings?
Oh, yeah. Yeah, that agenda has to be set and sent out and posted. So yeah, the staff needs to do that before you guys even get here. The public has to know what you're gonna be talking about.
We'll have applicants that'll apply and meet our deadlines, and so they're on.
And so
if
they
they
get
have a
on the
complete
agenda.
application, and then we put other items that we want to bring to you. So
I guess the only thing I was thinking is that if we wanted to get something on the agenda, we can just get a hold of you and say we need this on the
absolutely.
agenda, but it has to be before this 24 hours.
Yes.
So that the agenda can be changed.
Yes.
We can put an item on the agenda without a vote. I could say, hey, I think we need to put this on the agenda. You'd put it on the agenda. And then when we got here, we'd vote to accept the agenda or whatever we do. I don't even know if we do that. I know in most parliamentarian meetings that you have to adopt the agenda, but do we do that here? I don't think we do.
We have not.
But you see where I'm going? I'm like,
Yes, I see where you're going.
We haven't got a quorum, but I want to put this on the agenda.
in the past, we have had these type of situations arise, and the planning commission in a meeting like this said, hey, we'd really like to see something like this brought back to us. And that
On
was
the next
helpful.
agenda.
It was helpful when it was in a meeting and everyone kind of all the planning commissioners were there. And in most cases, everyone's like, yeah, I think I agree with that.
Yeah, I mean, I know we postponed a few items to a subsequent meeting, which I guess
Sure,
forced it to be on the agenda.
That was something that was already on the agenda, but there's been situations where a planning commission has said, okay,
Because they have to vote on it.
this agenda item got
Yep.
me thinking, and I want to look at something else. So,
The county commission does the same thing. When they do want to have us address something, they usually will, in a public meeting, take a vote to ask and request that be put on a planning commission
agenda.
meeting. So the county commission does the same thing.
But absolutely, you should all feel free to call and say, hey, I would like to see this on the agenda. You know, we'll follow the proper procedure, make sure it's vetted and it's legal. Brittany raises a good point. Even something that might be put on by a chair, for instance, says, I want this on there. I want to hear it. I think it's necessary for the board to do this. Any problem with that agenda item is cured by the fact that the board has to vote.
Yeah.
So even if there's something on the agenda that might be controversial, and some boards have a procedure where only the chair or the vice chair can put it on, and because they've had problems in the past. I don't think you guys have ever had that problem. But even in those cases, the rest of the board doesn't want to hear that. It comes up on the agenda. They can't do any formal action, just the two of them, or just the one of them. So it kind of cures any problem.
another tool we've had, and usually what we've done with the planning commission is that we have a work session option we can put. So it's more of a discussion item to kind of flesh it out to see what a potential land use application would look like.
Can I go back to just the predetermined actions really quick? So, I mean, like, even like a school board, even the county commissioners, they really aren't really supposed to be talking to each other. I'm just imagining a school board talking, because I know when I've been with Nebo School Board, like, I wasn't on the school board, but I knew a lot of school board members where they knew who was going to be at that meeting, and they knew it was going to be a raucous meeting. I mean, I can't imagine they're not having a discussion amongst each other of how to deal with that. But you're saying that that's not
legal.
That's not legal. That's
With
crazy.
a quorum.
Right, without a quorum,
Right.
you can still have
You
conversation.
can have a conversation without a quorum.
Yeah.
Right. But
So two people of a 7-member can get
There's
together.
administrative items.
Okay.
So,
that's-
a couple comments. It has to be a quorum, and that's why the 3-member commission is the worst kind. Now here, 2 of you could get together and talk, yeah. because it's not a quorum. Also consider that there are some bodies that have administrative duties also, and so they can actually do administrative acts without violating open meetings, okay? So there's a lot of things that, like, especially county commissioners do that aren't in open meetings, and it's not a violation. I know it might look like it. You might think, hey, that's county business. You need to do. No, it's administrative, so they can actually do it. Okay. But yes, open meeting violations occur on a regular basis, and we try to limit damages, mitigate, and cure every chance we get. And the best thing are these trainings where we put in people's minds, are we violating open meetings right now? That's the best question you can ask.
Okay, now just one more thing on that.
Yeah.
So I know we do get notice of the meeting coming up and a request to just acknowledge if we can be here. And there's no chance that becomes somehow a meeting or
No.
an agreement to be there or something with, because it isn't, that one's not in blind copy.
Right. No, you're just letting us know you're going to be here. We have to have a quorum.
But
or
you
start
would still
in
have to
panic.
be careful in a response on that to be.
Yeah, you shouldn't be asking, hey, I'm going to be there. Is everyone voting this way on this?
Yeah, okay, that's
That would be
that-
bad.
Okay.
Yeah.
And even in a response there to say, hey, will this be on the agenda? I'm just trying to think, is there, like, even asking about the agenda, is that conducting business?
No, because the email you got has the agenda. And maybe you'll ask, why isn't this on the agenda? At that point, no one's going to respond to you.
Okay,
We're going to just do that one-on-one.
okay. That makes sense.
You haven't convened a meeting.
Well, but if you ask a question about an agenda item,
If we got too many email responses and everyone's seen them, it could be considered
yeah, so
you're
that's
having a
why,
meeting,
As a rule, I tend to just reply instead of reply to all.
yeah.
which is good. But we learned that blind copy's better because not everyone looks at that when they hit it.
Right.
We've had that happen. And just so you know, the agenda has to identify the topic. And so you'll see there's usually a description of what you're doing, and that's necessary. Important on this slide, you can discuss other topics. And I clearly don't recommend this, but I understand where in your shoes, sitting there, public meeting, public person, bringing something up, and you're saying, let's just hear from them. That's okay. Not recommended, but okay. So it doesn't violate the law as long as you take no action on it. We will have staff investigate this and put this on a proper agenda later, would be the best response. We can't take action, we can't make a decision, but okay, tell us what you want us to tell. Yeah, that happens. And there's nothing wrong with that. Written minutes, I won't bore you with this, but it's good to know, to let people know. The written minutes are the official record. So when you approve those, you're doing something very important for us. You're creating an official, formal record that could end up in court somewhere. And so that's why we ask you to review them in advance. Think about, mostly make sure your comments are correct, because you'll remember your comments the best. But if also you read something and say, I don't think so-and-so said that, bring that up, okay? I found the minutes well done here. I'm not even sure who does them, but I was just very pleased with how they capture sometimes I sound better in the minutes. Very well done.
Maria, you do the minutes, right? Yeah,
They are. They're well done.
I agree.
And those are posted and those are available for the public. And we do refer to those on a regular basis as attorneys to go back and figure out what happened and why. Recordings, there's also recordings. You know that, or at least you should know that. Be very careful, in open meetings, everything's recorded, and we joke about it, but it's for real. Just be careful. Closed meetings.
Any person who presents information must provide a copy. Do we do pretty good on that?
We do. I think we could do better. The county commission even struggles with this. When someone shows up here and they start reading from something or handing something out, we want a copy. That's to recreate what happened in this meeting when a judge is looking at that 10 years down the road and reviewing your decision. We have to be able to see everything you had before you, okay? And that's why they can't give us anything after. We don't want anything after. If you've already voted and you didn't have that information, it doesn't matter.
So if somebody comes to the meeting and they approach us and start handing us things and they give you a copy, is it appropriate for them to provide that at that time, or should it have been provided earlier so that the public in attendance would also have that information?
I think it's most important that you have it and that we have a copy for the record. The public is not always going to see what's presented in these meetings. Now, they can get it after, okay? But it's not as important that the public know everything that you see before you make a decision. What's important is that you have it and that we have it in the record.
Okay.
Because whatever they do with it isn't ever going to be challenged in court.
So if they get up and say, well, we did a lab test and it was 46% something, we need a copy of that.
Should.
A copy of that, especially if they've got it in their hand.
Yeah. Yeah.
We
And
always,
especially if you're going to rely on it at all. I mean, if it's just talk, we hear a lot of just talk. People sometimes just need to vent to you, and you do us a great public service by letting them do that. Sometimes that's all they need. But if it's something you're interested in, like I remember like some tests on
Yes.
something or other. That was starting to get important. And if you were relying on it, I would want those copies in the record, yes.
And we'd want to actually see that, not just have it
Just not-
presented as a comment.
Yeah, just not, you don't know if they read it right.
we always think it's important that there's an applicant involved, that the applicant gets a copy of that too.
Definitely, due process.
So if they start bringing information like that, is it better for us to continue the item so that we have all that information in hand and you have a copy prior to a deliberation on that information?
There is nothing wrong with that. Now, some things are time sensitive and you have to balance. Am I going to make them wait? And you could even say, if you give that to me, I'm going to move for a continuance because I think this is really important information, but I think the applicant needs to look at it. I think I need to digest it. I think staff needs to look at it, and then we might do a continuance. It's fair to warn people about that. You have to be comfortable with your decision.
But sometimes that's what they want.
You to be not comfortable and
No,
uninformed.
they want you to
Oh, to
continue.
continue, yes.
Because they
That's
stall,
what-
they think that stalling it prevents it.
And that's why you're balancing. And if it's time sensitive and you feel like they've had time, you say, I don't want to see that. I don't want to accept that. You have the right to do that too. Okay? Because if anyone were serious about getting things in front of you, they would come long before your meeting. Okay? Either maybe in time for the packet.
I'm just thinking from last meeting, the mayor of Fairfield came up and had a bunch of pictures to show us. And that was kind of last minute.
It was.
Didn't, cause a huge problem, but that potentially could have,
Absolutely.
because the continuum and then the license would have expired and all that.
Yep. Well, in that case, you might decide, we're going to go ahead. You had time to get this to me. You guys knew that this was noticed up, and so you just have to decide what's the fair thing to do. You really sit like a judge.
And I seem to recall her saying that she had only found out about it like the day before or something
Yeah.
like that. So
Not sure about that. Not sure about
But
that.
I do think it's important to remember, though, that, we live in a capitalist society, that you stall a project a month.
yeah,
And that can be tens of thousands, if not hundreds of thousands. And if you push it past a building season, then it can be 6 months, because asphalt has to be laid at 55 and above, and so it is that balance that you have to find
We will
out.
try as staff to kind of help, because certain applications before you are administrative, and some of these things shouldn't really be considered. And other things, maybe there is more deference, and so we'll kind of be there to help distinguish that. Something, if you're doing a conditional use and this is something that doesn't really apply to the standards and requirements, then it's something that, you can just say, well, that doesn't really apply and shouldn't be considered. We can kind of help filter that.
Closed meetings, I don't see you guys closing, here are the permissible closed meetings. I don't really, I looked through these today, I was like,
gonna
I
do a
don't see you
contract or
ever doing this. However, you need to know about that there are legitimate closed meetings where, if you ever come to a county commission meeting, you might see one, where they have to vote, close it, remove everyone from the room, it's a closed meeting, and then they come out of the closed meeting to actually do the business. So if you're ever gonna take final action, they'll come out of the closed meeting and actually do the final action. But just important to know, if someone questions you about closed meetings, yeah, they're allowed by law, but we don't have those.
And you can't take action in those.
You cannot take action in a closed meeting, yeah. Yeah, that's the catch. Yeah, you can close and have your discussions, but you can't do anything in that closed meeting. More requirements for closed meetings. Again, I just don't think those are really important for you guys. I'm glad you don't have closed meetings. They're not fun. They usually involve things that aren't enjoyable, and those are the ones that end up getting litigated. Maybe that's what I'm trying to get at, why they're not really that great. Emergency meetings do happen. I guess I could see this happening, like especially during a COVID type situation. The county does have a policy for an emergency meeting. We would do our best to avoid that because you don't need the hassle, okay? So if there's really something that critical and we couldn't meet, there's an earthquake or something, or, this building shut, well, we did have that. The electrical shorted out our building one day, and if that had happened on a Tuesday and the police and the fire wouldn't let us in here the rest of the day, we would have had maybe an emergency meeting there. I'm not saying we would, but we would definitely look at it, and it's possible it happens. We also have a policy for electronic meetings, having people join. Still don't recommend those. This is the best way to do an open meeting. You're sitting here facing these people. There would be people here. You know what I mean? Open meeting violations, just quickly. It is a Class B misdemeanor, so take it seriously. Especially if someone's doing a predetermined action, trying to figure out a vote beforehand. Speak up, or just get out of it. The court can void actions that are in violation, award costs and attorney's fees, which comes to the county, so we pay that, asking you to be careful so we don't pay that. We can cure violations, which can be done. If there's something happens and it wasn't done correctly, we can call another meeting and cure it. So there is that benefit. And then anyone can enforce OPMA, which is probably a good thing. We call them private attorney general actions. They just, or they're watching us and policing it. Common ones, failure to provide notice. That's not on you. Don't worry about it. Closed meetings, 2 of those are closed meetings because a lot of the litigation is on closed meetings. Don't worry about that, or taking action. Yours is probably going to be predetermined actions. Okay, so just be careful of that. Any questions on open meeting?
So what would happen if we're here, we're in a meeting, and the fire system gets tripped, sprinklers start happening, we have to leave the building, but what's on the agenda, we still have some business that was announced was to be taken care of. Can we move the location?
Ooh. That's never happened to me. First of all, we would get out of here and probably adjourn, powwow, decide if we should renotice it up. That would probably be my preference. Renotice it. We need 24 hours notice. We meet somewhere else. It's on Tuesday. We meet on Thursday or Friday. I would do everything I could. I would wait until the next month for everything that could. Simply continue it until the next month. Anything that had to be time sensitive, renotice it up would be my reaction to that. Because then we give people a chance to be here in another location where they can address you directly and do it right. Okay, good. Okay, we got it. I gotta hurry because I don't want to lose you guys. Okay, so here's what. Oh, sorry. Here's something we put together, thinking it would be helpful to you.
but it's also helpful to us to help you do your jobs. We've noticed that we have neglected to really talk about your duties and what you're doing. And we apologize for that, okay? We do this all the time, so for us, it's just second nature, and we sometimes forget that not everyone is in this world. So let's just go through here. This is something you take with you. We can talk about it again. We can, go into more detail as much as you want, okay? As much as you have time for. So this is just a general script that we've kind of taken from other notes, other things we've done, and just trying to think through how it's best for you to run a meeting. So it's very commonsensical and flows and it's logical, okay? So we have provided actual language here so that, heaven forbid, we don't have a chair, we don't have a vice chair, we don't have a Karen who's like a pro at this because she's done it. So, you're stuck here as one of the 4 members and you've never run a meeting. I think you could do it from this, okay? So trying to put something in your hands so there is no stress about this job, okay? You would simply have this. We will always have this available. You don't have to keep your copy, but we would just give it to you and say, hey, go to town. Because it's really 1 through and a whole meeting. You're calling the meeting to order. You've seen your chairs do that. Here's something a little different. Announce. We would like you to announce this. Please sign the attendance roll located by the door if you desire to speak to the commission tonight. And please indicate on the attendance roll which agenda item you wish to speak about. There was a resolution done by your board back in 2013 requiring public comment. That is not required by state law. Now, it's honorable. I think it's okay. But what it does, and by the way, you can always change that resolution. We are bound by it, but you can change it anytime you want. You want to do a new resolution, we'll do a new resolution. But here's what it says. The public can comment on anything on your agenda. Now, that can be a problem if it's a contentious item. And public comment cannot be used in your decision, which we will get to. So, you're opening yourself up to a little time commitment by listening to everyone who wants to speak, and possibly wasting your time, because if they bring up things that are not relevant and cannot be considered, we'll be looking at you to say disregard. But as you've seen, sometimes it helps the process if you let people talk. Even though they can't change things, just the fact that they were able to talk to you. You had one lady stand up and say that. Thank you for just listening to us. We realized you couldn't do anything, but the fact that you listened to us, it made it okay. Means a lot.
So builds trust in.
Trust in government.
Yeah.
So that's why we want you to announce that, because it's actually in our resolution. We're required to take public comment on everything, not just public hearings. There's a difference, and we'll talk about that.
That resolution was by the planning commission?
It was, yes.
By the planning commission.
Yeah. Which you can do. You have the authority to do.
So when the chairman sees Bryce going like this, does that mean he can?
Yes, we will get to that.
Oh, okay.
The chair should have their own class, unfortunately, because there's things the chair can and should be doing that you just kind of need to experience.
I have
Okay.
a question or
Yes, ma'am.
feedback, really. We've discussed the implications of that resolution. With that resolution in place, I think it would be helpful if we had 2 sheets there, one that just said attendance and one that said request to speak. So when you're looking down that list, you're not trying to look at both the
Oh,
columns
yes.
saying, oh, did you want to talk? And what did you want to talk on?
That's confusing, isn't it?
It can be, and I think for the public, it's a little bit confusing
Okay.
too, where they're not sure what that they're actually putting their name to.
Okay.
That I think would be helpful.
We actually used to do that, and we found people weren't signed in who, it was hard, but we'll look at some different versions for sure.
Do we have to have an attendance roll? I mean, they're not part of the meeting, so we don't need to have recorded that they were here, right?
Good question.
Yeah, that is.
That may be a remnant of an older law, but
Yeah.
we'll look into that.
Yeah.
This is not something I've seen
Yeah,
elsewhere.
no, you're right. It's not required by law. We could call it a speaker's role or a comment role or something like that.
Request to
Right.
speak.
Yeah, request to speak role.
Just to be really clear
That
what
might be
what it
helpful.
is. And they don't feel like they have to put down that they were here just to
Right.
be here.
Well, as you know, these days someone may object to that. I don't want to go on the record of being here. you know?
Exactly.
Well,
So, it's a good
when I
point.
came in for the first time, I hadn't officially been sworn in or anything, but I wanted to attend and just.
So you signed the role.
I came in, but I was like, I don't know about signing. I'm not here to public comment, so I just sat down.
Okay, good point. That might be worth doing because we've noticed that you guys struggle with that.
Yeah.
In these contentious ones, who wanted to speak and on what? We'll work on that. Of course, approval of minutes. I told you how important those are, so we just follow that. It should always be the first thing you do. Unfortunately, there are some boards that have to meet to approve minutes because they don't meet enough, and if we don't have official minutes, there's no record. And so we will convene boards just to approve minutes. It's sad, it wastes time, but it has to be done. And luckily, you guys have enough business; you don't have to do that. Now, on number 4, not everything needs a public meeting. Okay, public hearings are required by statute. It's not something we made up. It's not a part of a resolution. It is state law. But not everything needs one. And they're good to put it on the agenda. It's there in bold. You know you're having a public hearing. 4 is there if there is something on your agenda. You need to open that public hearing, and you guys know how to do that. And then we gave you a step-by-step on agenda items, and we hope this logically it flows, okay? Every item, invite a staff to present it. That seems to work really well. They kind of tee it up for you, give you the issues and the information. And then ask them questions. They are there to serve you. Ask your questions while you've got them there, okay? You'll have another chance to, but ask them questions. Then the applicant to speak. We need the applicant to have their own time before the public really starts attacking. And so give them that time and then ask them questions. I think you need to put them on the hot seat. If there's something you need to know, you let them, you ask the question. And then, of course, the public comment. Like I said, the resolution, and we can get that into your hands too. You probably ought to have that. Those are your rules that you made. Well, your board made before you. They're actually very specific. 3 minutes initial, 2 minutes rebuttal. You can't share your time with others. You have to split it between agenda items. It's very specific. I didn't do all of those here because I didn't. You guys seem to me to be a board that's not going to nitpick. And well, you spoke for 2 minutes on this. You only get a minute here. You'll probably let them go 2 minutes, and I don't have a problem with that. So I didn't put all of them, but you do have more rules. We put the most important ones here, such as don't repeat things. You can simply indicate that you agree with previous comments, and I think this is good script. You just read it to them. We only receive comments and do not answer questions. I think that's critical to tell people because they think that you are on the hot seat and they can ask you questions, and they cannot. Now, you can answer them if you choose to. We do not recommend that ever, okay? It's just not a good idea because even though you might know the answer, if you don't have all the information, that answer could hurt the board, the county, and you don't need to answer questions, okay? And then it goes in order. Your resolution says that. I threw in F because, as you have pointed out, not everyone understands the role. They come here expecting to speak, and we don't call on them. Just ask, is there anyone else? Yeah.
You said we shouldn't answer their questions. What about us asking them questions?
Not a problem.
Okay.
Not a problem.
I have a question.
Yeah.
Going to public comment. So if we can't really be swayed by public comment in making a decision, then what's the point in public comment?
Like I said, that was by resolution. It's not required by state law. I was not the attorney. involved in that resolution. I don't agree with it. I may not have done it. I may have advised against it, but we're kind of stuck with it right now. Now, the way the county commission handles it, in my mind, works better. They actually have on their agenda, right after other business and before adjourn, public comment period. Now, they've already done their business, so maybe it doesn't matter. But we found that if you give people a chance to say, hey, that was a stupid decision, you didn't listen to anyone, you didn't do it right, it gives them a chance to do that. But it doesn't affect the actual decision up in the agenda because we've already handled that business. I like that approach, but I'm not saying that there's anything wrong with this approach. This is the way the resolution is written. That's why we gave you the script this way. Until it's changed, we feel obligated to follow that. But you're right, Lorraine. It's risky because I can tell you if it's an administrative decision and there's a lot of public comment before you vote, it's very easy for a plaintiff's attorney to tell a judge, because this will happen years later, play the recording, Judge, you can't tell me that those commission members didn't consider those public comments, which had nothing to do with that decision. And when they got their decision wrong, that's why they did it, and you need to reverse it and give us our permit. I think they can win that. If I were a plaintiff's attorney, I like that. So
So in the scenario with the a couple months ago with the biosolids issue, and you had the person from BYU come in, and they had, I thought they introduced some interesting data. It seemed like it was evidence-based. I'm not supposed to consider that in my decision.
maybe not.
Yeah.
You have to look at the conditional use permit. If it's going to a condition, if it's something that legally you can look at, yeah, you would. But I was biting my lip over here. I was like, oh my goodness, this is getting really uncomfortable for me.
It kind of depends. There was a matter that was a public hearing. I mean, we were talking about a text amendment, and so that's something different. Public hearing, you could completely consider these type of public
You have to.
comments. Yeah,
Okay, so
not
so
all
now
public
that's what I'm
comments
getting
are created
confused
equal.
with. So there's the public comments versus public hearing.
Yes.
So the public hearing, I can take that information back and then make a decision. Okay, so that's what I'm getting, because I'm like, what do you mean we
Yeah,
can't?
there's two different things going on.
Yeah, the difference is if it's an administrative versus a
Okay.
legislative.
And even on the public comment, there's certain factual things that can be brought out through those public comments that say, hey, you got to be this distance from someone in the property neighbor next door, and you're like, no, property line's here. There could be some factual things that could be incorporated as part of a condition, like Dale said.
But I think best practices on an administrative decision would be no public comment until after the agenda, the action item is done. Like the county
So
commission.
maybe somebody can prepare. Does somebody want to prepare a
Just
different
is.
resolution?
So we do backwards of what we did last time. We do backwards of what we did last time. Instead of having 2 hours of public comment and then making our decision, we would have made the decision and then had all that feedback from the
Unless
public.
it's a public hearing.
It wasn't a public
There-
hearing.
well,
It's an
there- one of them
administrative
was a
item.
Yeah, right. Yeah, I don't know why the resolution was written that way. I can't explain it to you. I wasn't here. I haven't talked to anyone that was here. It's just the way they decided to do it.
So it seems like you might be suggesting that we have an because I feel like even since I've been doing this for like a year and a half or something, that I feel like, and it makes sense, that it's gotten less simple.
Yes.
And I can't imagine it getting, we going the other way with, and at some point you kind of think, well, this is not what, I mean, you know what I mean? Like at some point you feel like that's kind of like what you're talking about with the public hearing. It seems like it just makes the process, it would frustrate me personally if I felt like, I'm going to speak, but it really doesn't matter.
Yes.
Right? That would make me mad if I was in the audience and like, I'm going to say my piece, but it doesn't matter. And
Which we had with the permit extension on Snowbird. There was very little latitude there.
right,
Very little discretion. We had lots of public comment.
right.
But
And was not required.
I think we handled it well. I think
did.
I think we let people
Handled it
know
well.
up front about this is what you, if you have that many people there that came to speak, even after their instructions of what can and can't be contemplated, and then you say, well, we're gonna decide first, then we're gonna let you talk, that wouldn't have gone over well.
And, just my experience, when I served in the legislature, my experience though is when the hardest feelings is when the speaker cut debate short. So even if you got, if you had strong feelings about a bill, as long as you got to speak, even if you lost it, it was much less bitter than if, and a lot of times those decisions are predetermined. You're going to lose anyway. But if you have a right to speak, and I think that's kind of the sense. It did go long, but I think that's how some of the people did feel.
I think that's where, sorry.
No,
I think that's
go.
where, the chair has to play that role of keeping them on task.
Can I request that resolution be sent out by blind carbon copy to us? I don't think I've seen this resolution and the verbiage of
Any
it.
of them, really. We don't know what our rules are.
That's our fault. I apologize for that.
Yeah, if you could send that, I think that'd be good. Just
Put an ad hoc committee. Oh, except for
Each of you got a copy when you were appointed as a planning commissioner.
did we?
So,
Oh.
it is in your email, but we understand. You probably didn't look at all that.
But we should be bringing these up and training on them on a regular basis.
So just also with public comment, I think both Bryce and Dale are just being clear that if you accept public comment, just make sure that it is specific to that, and that if it is a conditional use or administrative decision, that it's any decision you make or get influenced by is acceptable to that conditional use. It can't be just somebody making comment and expecting you to take action on something that isn't germane to that specific item, and you have the ability to take some action on that.
And if you're wondering, you ask. We serve you, okay? We are your staff. All you have to do is say, well, can we even consider that? Or where is that in the code? We will help you do that, okay? You don't have to do that on your own.
make
You
them
have
the
enough
bad
to worry
guys.
about.
So what steps we take as commission to maybe just revisit that resolution? That was, what's the
Let's put it in
steps?
your hands, and you guys can,
We can have
you can put it on agenda. We can have a work discussion on it.
Yeah, I think that's worth, like I said, I do think, I'm gonna get frustrated if I think I'm driving all the way from wherever, Timbuktu, and I'm gonna have a say when it didn't matter. I think that's a little, I don't know, it's not,
I don't disagree with you. I just think
a lot of integrity there,
it seems like
honestly.
we ought to read it and just
Yeah.
see if there's something
So-
on there that is.
So I don't know, I don't mind having that, let's put that out there to just revisit that.
Can we put that on the agenda too? Can we ask for that to be in the other business for next meeting?
Absolutely,
Just to discuss it? We don't have to decide anything. We just bring it up as a discussion item.
absolutely. Yep.
Yeah.
Okay.
We'll get that in your hands. I added G just because it seems like it's always not clear when you can discuss.
Yeah.
But we really want to have a session, a particular time in your process where there's that discussion, because that is really good before you make a decision. Sometimes,
Robert's rules, there's a motion and then it's the discussion that takes all the time
should.
before you can call for the vote, right? Basically that, and generally around here, we do all the discussion, then we call for a motion.
Right.
And by that point, we're all just tired of the topic, I guess, or something, but there's no discussion usually after, but that's usually where there's discussion.
Right. Well, and Bryce is right. I just found my copy of the rules, and we follow Rosenberg's. What is
We do.
Rosenberg's?
Yeah, the board decided that we should do Rosenberg's rules. We'll train on that, okay? Because they're a little different than Robert's. But by and large the same, but yeah, we follow a different group of rules, parliamentary rules.
Was that determined by the county or this group,
That's
or
in
is that
county
the county, the way the county does it?
Oh, yeah, it is.
That's in county code.
It is in county code.
Yeah, so that's county commission, but you could recommend a change.
Yeah.
Since nobody
That's
knows
what they
who
use.
Rosenberg is.
Yeah, I didn't until I got here, but It's fairly well established. They come out of California. They're a little bit simplified. I know California, that's a bad word. But it seems like they did a good job. When we go to our conferences, they'll sometimes debate Roberts and Rosenbergs. And anyway, we will train on that and see if you like them. Sometimes, as chairs know, you have to invite a motion. You know, everyone's kind of sitting around. Sometimes you have to say that. Hey, when someone's ready, we'll entertain a motion.
Yep.
The vote, so here's something new that we thought we'd throw out to you guys and make sure you're okay.
Are you guys having a closed meeting right there? What-
Wow, see? That works. You didn't notice this, but I took the pledge out. Now, there's no law that says you have to have a pledge. There's actually no rule that we could find that says you have a pledge. You decide whether you have a pledge. But since it's not in the resolution of your rules and order, I took it out. I think it's been on the agenda because it's always been on the agenda. And it seems like a lot of commissions do it. But again, that's for you to decide. And that's why I took it out. I was supposed to tell you that. I forgot because it's not in your resolution. So when you take a vote on a motion, you can continue to do roll call if you like. You don't have to. Here's where that rule comes from. The minutes have to identify how each individual voted. Someone listening to a recording and doing minutes needs to know who voted for what. So the way the county commission does it, which I think is what I'm used to, is if it's unanimous, we don't roll call because we know everyone voted yes. But if you hear a nay, then you do a roll call so that the record is clear who was that. Maybe there were 3 nays. Who were they? So then you do a roll call. So that might help you.
I think
going forward.
I think that we were instructed to do it that way.
You were instructed, but I think it was just a misinterpretation of what you're required
Yeah.
to do. Electronic meetings, if you're all on a phone or a laptop out
You'd
and
have
we're
to do a
sitting
roll
here
call.
recording, then you have to do roll calls. So
Does it make sense for anyone? So just
Yeah, absolutely.
All in favor? Aye. If it's unanimous, if there's no nays,
yeah, if you s-
then we don't need to do a roll call. Individual
if
vote.
you say any opposed and there are no nays, you don't need
You
to roll
should
call.
be asking if there's any opposed.
Right,
correct?
you always ask
Yeah.
if there's any opposed. You'll see that. All in favor? Listen. All opposed? Okay. Then, of course, I follow up with, and use that same procedure on every item, okay? I know it's a lot, but you really need to cover everything for each action item. Then close your hearings. We always close hearings at the end when we're done with them. The other business I added there, just something to trigger your minds.
In Robert's rules, you could say, I don't know about this Rosenberg, what is it?
Rosenberg.
Rosenberg. You could say, we will close the public hearing without objection. You could say something like, if there's no objection, we'll close the public hearing. Is there any objection? Hearing none, the public hearing is closed.
I think you could do that.
You could do something like that. I mean, where it's like everyone knows we're gonna all vote yay anyways, so unless there's an objection, it's just adopted.
meeting going.
Yeah. So that's maybe another way to do that one.
It is.
Yeah.
It is. This is another way to say it. Other business, I included there just that note that if it's business you're gonna do something about, it better be on the agenda and it better be noticed. Other business, such as what we're doing now, doesn't have to be noticed. It doesn't have to be on the agenda because it's not formal action. You're not doing anything that your board would normally do. You're just receiving information. We will usually take over for the other business because it's usually something that there's no formal action. It's usually us doing whatever we need to do with you. Sometimes we had that discussion about emails. And then, of course, chair, you just close meetings, very easy. The next page is a summary of some of your rules in your resolution. Okay, there are more. Just reminding you what a quorum of a 7-body quorum is. Your quorum is 4. Alternates, there's rules on alternates. You can see that there. They only act if there's fewer than 7. We follow Rosenberg's, which we will train on. Don't worry about that. You guys pretty much follow them anyway. The difference between public comment and public hearing is public comment is not required by law. and can just be done at the end or with each agenda item. Public hearings are required by law, and those objections do go to the county commission. So they are very important when you hold a public hearing and you take comment. The county commission is supposed to receive those, and they do through the minutes, okay? And public hearings is really a free-for-all. That's what they're designed to do. Anything and anything that would come before us for this, before we take this action, now is your time. Forever, speak now or forever hold your peace. Group comment, people can combine. We saw that a little bit. Instead of 3 minutes, you get a real talker. They want 7, so they'll get their buddies to join a group. Comment limits, there are limits on those, the time. We try to stay those. You guys have policed that pretty good. Rebuttal comments, I haven't seen people do rebuttals very much.
What's the definition of a rebuttal?
A rebuttal is
Disagree.
you take your 3 minutes, everyone gets their 3 minutes initially, and then you get 2 minutes to come back and respond to anything anyone else said. I haven't seen anyone do it, but they could. They'll get 2 more minutes. Is what
Really?
they
So
get.
that is actually, yeah, because I would have thought they didn't have a right, but
Yeah,
they
they
do
do.
have a right, a 2-minute
do.
right.
We have had a few people who have done that, where
Jump
they've
back
come
up.
up, they've said something, and
Yeah.
then 10 other people say something, and they say, "Can I add something?"
Yeah.
Or they just shout it from back there. But
So what you should do is you say, wait for your rebuttal, finish all the initial comments, and then start at the top rebuttals. That's the way it should go.
Let's keep that a secret.
Yes.
Keep rebuttals.
So much for the open meeting stuff we've had.
And that's something we can address through a new resolution.
We can't. Keeping order. This is where the chair comes in. Chairs actually do have a lot of authority, and we need that. You need to be able to cut people off. You need to be able to stop repeat information, and you need to stop them when they're over time. And we have a good deputy, and if we ever need that, we'll use it. People need to observe your rules and be respectful.
I think if we had a way of watching a timer and even something that would show up here, do we
It's
have
right
those
there.
come up
It's
when
right
we
So
have
it's right
comment?
here. I don't know if you can see it. This little black box.
I can't see it from here, but
And you might
usually
not.
It's usually
look
turned,
different.
yeah,
Yeah,
it's
it's
usually
usually
right there.
so I
That
don't
would
know
work.
if
For you to
that's
see, but
It's bright red, it's just not plugged in.
yep. But I mean, like when we are taking comments, especially on a
doesn't it make a
heavy
noise
item.
when it gets to 0?
Seems like
we
it makes
did
a
use
noise.
that in our last meeting when we had lots of public
Once
comment.
it gets to
Wrong
the end,
mother.
it will beep, and then I can beep it again if needed after that, just to give them a second reminder after like 10 seconds or something.
And I might propose the possibility of having 2, one that faces us, just because, I don't know, I mean, it's a little disruptive to be like, ooh, like they know our attention's there. We're just sort of like, when are you going to be done?
I guess if the timer goes off.
Yeah.
It is. And
If
really,
it has a buzzer, then we could hear it.
and
we
only
don't
the
have to
chair
watch
needs
it.
to be watching it. Everybody
Yeah.
else can focus on
saying,
the speaker.
might be nice to
Just
have
the
one.
chair.
I was thinking if you could get one on the screen
gonna say,
here,
some
that
entities
they could
put it
then
on the
see
screen.
up there would be
Appeals courts too.
nice, but anyways, I
Because I'm
guess.
focused this
Blinking.
way, and I want to see like what they're saying, and I don't want to be distracted looking that way. And I know, obviously, I'm not sure, but like still, I think still that
I
there's.
think if we can use it, it would be good though, Marie. So if we know we're gonna have a lot of comment, we did, okay. Good.
You might
It was
just pass
helpful.
that on, Marie, to the commission. Just say, hey, can we put another monitor up here for the timer? That they might actually want it too, the commission.
Yeah, I spoke
Bring it up.
to Jolyn about it.
Have you?
And that one's old, so she's trying to, like, it's very, very old. She's trying to talk them into maybe getting something new system, but that doesn't sound like it's gonna be very favorable right now.
It might be if they hear the planning commission wants it.
I will let her know that.
Awesome.
Let's find out how much it costs first.
I can't imagine that's going to be a lot of money, honestly.
Put it in my
Yeah, I
budget.
can't imagine.
Honestly, like
It's
really,
theirs. This is their chamber.
that doesn't seem like that's going to be
But
like.
I mean, you could also get an app that you can display on the screens.
Good.
That way everybody can see it pretty well.
IT could do that.
Look into it.
Written materials must be submitted before your vote. And abstentions, we don't see that very much. Thank you very much.
You can.
Amazon
Appreciate
has
that.
all the bugs.
Probably shouldn't have mentioned it because we don't like it, but there, you guys have raised conflicts before, and it's necessary to abstain and
conflict.
leave the
In the
leave the
legislature.
board there.
If we have four and one abstains on an item, that doesn't
It
affect
does
the
not.
quorum.
We can continue the job, yeah.
Got it.
Okay, last, I promise this is it. Just a smattering of some of the law that usually comes up. Number one, the recommendation standard. That's for legislation. That comes out of ordinance. I think it's very valuable. They just want you to consider, when you're recommending legislation, make sure it conforms to the general plan, of course, which is our guiding document. Always in the best interest, health, safety, and welfare. Everything we do is. And then more fully carry out the land use ordinances. So, good reminder as you're looking at something legislative, which you can consider public comment and public clamor. So, you know, you have a lot of discretion there. These sometimes give you a thing, well, you know what? I like what you're saying, sir, but it doesn't conform with the general plan. It's going, in fact, we had one, I won't bring it up, but we had a recent one which had to do with housing, which seemed to go away from the general plan's ag focus. And so it's okay for you to say, I have to follow the general plan generally. And so those might be helpful is what I'm saying. That's for legislative decisions, text amendments, new ordinances. Consider those things. Those are an ordinance, so they're required by law. And if we're ever challenged on it, we could say we followed those three things. Ex parte contacts, you already learned about this the hard way. And truly, the rule is this simple. If anyone approaches you outside of this meeting or outside of the official channels, report it. Just report it immediately. We'll tell you what to do and how to handle it. Then you can never be caught off guard. If something happens on the way to your meeting, so you didn't have time to report it in this meeting. Like as soon as we get done with approving minutes, that should probably be, Chair, I have to disclose something. This happened to me. You know, someone called me on my way here and they told me these things and it needs to be disclosed to the board, okay?
Let me ask a question about that. Pardon, sorry. So I sit on another board, and one of those board members is the water master for American Fork Canyon. And so they were present during the reconstruction of Tibble Fork. That was part of their job. You know, when they had that release of contaminated water and stuff, that was you know, occurred during his watch. And so when we were at this board meeting, it was after this other board meeting, and he started talking about that, and we had a brief discussion about the Snowbird extension. He was not affiliated with Snowbird at all. He wasn't participating here in the public hearing or anything like that. I did gather what I felt was pertinent information for me, because I felt, you know, based on some of the comments that we had seen in emails, that there was going to be discussion about the release of the contaminated water and stuff like that. How does that apply to ex parte contacts?
It's probably something I would disclose. So, you know, I had this contact with a person who had this information. I'm disclosing it here. This disclosure will always be your cure, will always be your safe harbor. No one can ever accuse you of doing something improper, illegal, if you disclose it. Okay? So if you feel like at all it was relevant to something on your agenda and it provided some inside information and possibly sway one way or the other, I would disclose.
And that's at the beginning of the meeting, or?
Yeah, so you don't want to disclose that after we've taken action.
Right.
That would be too late. We would probably, it's never happened, but I could definitely see us backing things up and saying, well, we'll renotice this up.
When is he disclosing it? Like when? In this whole process, when is he like coming to you guys before the meeting starts and whispering in your ear? Or?
Well, I would disclose it as soon as it happens. So if you had this on like a Friday before, I'd be sending an email to Bryce and Marie saying, hey, this happened. I want this disclosed. And then we would make sure that's either disclosed to all the board before, it's put on the agenda, whatever we have to do. Okay, we'll sanitize that and make sure it's okay. But I would report it immediately. If my example was someone calls you on the way to your meeting, you don't have time to get it to us to try
Okay.
and take care of this.
Yeah.
I would just, as soon as the board, as soon as the chair is done approving minutes before you start the agenda, I'd say, I have something to disclose. Or, you know, as you're walking in before the meeting, grab one of us, hey, what should I do? The best thing you could do is let us know. We will do whatever we have to make sure you're covered and we do things right.
Now, what if I'm kind of a research-oriented person, and so I want to see both sides of the story. So what if I'm doing research on a topic?
Are you talking to people or just Google?
Probably Google, probably chat, probably
you're fine.
deep
This-
research chat.
This is an ex parte contact, meaning a communication with someone. But what this is trying to do is prevent people swaying you behind the scenes or coercing you or worse, blackmailing or bribing you. That's what we're trying to get away from. That's why these ex parte contacts are not allowed.
But, I mean, how do you balance that with, you know, I think a citizen has a right if they have an issue that's pretty strong. I mean, don't they have a right to, you know, but it's supposed to
Bring
be.
it to this meeting.
It's supposed to be at this meeting.
That's
so-
exactly, as soon as they start on that, you say, you know what, you need to come to our meeting or send us an email. You really need to do it the right way. Because
Just to make
approaching
sure
me,
that everybody gets that same information. Everybody's
Transparency.
working off the same.
all of you, the applicant, staff, so that everyone can react to this appropriately. That's the way I would handle it. Say, this is good information. Thank you for bringing this to my attention, but you need to do this the right way. And either tell them when the meeting is, or give them the email, planningcommission@utahcounty.gov, and it gets to everyone.
But there's nothing wrong with us going out, doing research, getting informed on a particular
No, that's
issue.
not
That's
ex parte.
that's just us doing some research and educating ourselves.
Right.
But
Ex
if we
parte
met
is-
with the applicant or something like that, then
Yeah.
Oh, definitely with the applicant.
yeah.
That's a violation.
Or-
Definitely applicant,
Or somebody that you know that opposes it.
and it could be any of the opponents, yes.
So now, what if it's a situation where I actually might know somebody, and maybe I haven't done business, but my husband has done business with that person? Do I need at that point step aside and not be part of the decision-making process?
Now, that's a conflict.
Even though I feel like I can be unbiased.
If you feel like you can be unbiased, you're going to be okay.
Mm-hmm.
If you're concerned about it, you disclose it.
Oh, okay.
Or if
Interesting.
it could be perceived as
Even the
something that
appearance.
we would, if we found out about later, think that you had a
Super
bias or an
conflicts.
undue influence.
Well, you don't know. I mean, you really don't know. I mean, I know one person used to be the kids, you know, like Maple Mountain history teacher. He came in and like I knew him, you know, I saw him. Oh, hey, you know, we kind of met eyes. But I don't know. Is that something you disclose?
I voted against my former,
We're gonna know people all the
We'll do
time.
we'll do a
and-
conflict-specific training. But it's kind of a gut feel. You know, something pops up on the agenda and you start recognizing people or the place or, you know, heaven forbid you're part of that company that's doing that. Yeah, you disclose. Like I said, disclosure is the key, is how you keep yourself safe here. No one can ever say you did something wrong if you disclosed it and everyone agreed you could go forward.
Sense.
And I think you did one once, Lorraine, where we talked about it and I just said, hey, just step off. And
Yeah.
you did.
Yeah, I did.
Safe.
Yeah.
Always safe.
Yeah.
Yeah. And we're also careful about the reasons for your conflict. We're not necessarily going to disclose those to everyone, okay? Because we don't want to give them any other additional information. So conflict is like bring to us. We'll decide if it's, you know, really conflict. If it's bothering you, it probably already is.
Could be.
Okay, lastly, this came up in a meeting, that's why I put it here. You have two different jobs. One's legislative and one is administrative. And you really should be asking yourself that every time you have an agenda item. Am I legislative or am I administrative here? Because you have a different hat. and you have a different role and you have different obligations. So legislative, the easy one, the one we all love, you're making law, okay? Anything you do to create a rule, or your resolution will be law if you do a resolution on meeting procedures. Whenever you're creating something, it's legislative. And that, the discretion is wide, okay? Courts will rarely second guess you. You would have to be way out in left field for a court to ever second guess a legislative decision, like completely off base. If it's reasonably debatable that it advances the general interest, even if, everyone disagrees with you, if you believe it's in the best interest of the county to pass this law, your decision will be upheld, okay? So legislative decisions really don't bother any of us. I don't know that they're ever litigated, okay? Because you can consider all kinds of public opinion, clamor, protests, whatever. It's legislative. We're creating law, and you need to hear from everyone in anything. It's the administrative decisions that get us in trouble. And that's why it's good to identify that. Chris did a good job the other day of saying, hey, is this an administrative decision? Isn't our discretion fairly limited? Exactly. And we're okay with you doing that on the record and putting us on the spot, because that will help you. The county commission does this all the time. Well, Mr. Eric, do we really have any discretion on this decision today? And if the law says no, I tell them no. They want that.
Is there a way that we could put that on the agenda? Just say, hey, this is a legislative, this is administrative.
Yeah, we usually don't go that far.
Okay.
They are
It's
smart.
good is if it says public hearing, it's legislative.
Yeah.
Oh, yeah. Definitely public hearing on that. And so those are where you enforce law, apply law, interpret law, okay? You're acting kind of like a judge. And that's why your discretion is limited. You have to follow the law. And when you don't follow law is when we get sued. So administrative decisions are important. The standards must be supported by substantial evidence in the record. Now, that's staff's job, okay? We're making sure that the application and all the information and everything, if there's not substantial evidence to support something, their staff report is gonna say that. We do not recommend you do this because there's no evidence. But that will rarely happen. There will be evidence that's just not gonna get to you. Where this comes up is, if you say something like, I don't like this, I don't want to approve this, can I do that? That's a fair question. We're okay with you asking those questions. Those are hard questions. If there is if the staff report's saying there's substantial evidence, you can question that. You can call them out on it. Say, I want to know about this part of this. Is there substantial evidence? We can document that. But if you're thinking about denying something and there's substantial evidence, bring it up. During that discussion, let's talk about it. Because that's when we'll get in trouble. Because the court isn't necessarily going to care about your opinion. They're going to care about the evidence before you. And if you disregarded it, and that applicant was really entitled to that permit or whatever it is, that's where we get in trouble. Conditional use permits, the case law is legion on litigation with conditional use permits. Sorry you guys got that job. I think you're the right people to do it. But it's a big job. And you'll see that in the coming days. The standards is very clear. This is statutory, reasonable conditions, mitigating the effects, and staff reports are your go-to. They'll outline it for you, okay? Feel free to question, feel free to ask for information, but that's where your discretion starts to get limited, okay? The denial, and we don't need to get into this right now, but we could actually do specific conditional use permit training if you want, but you have to find some things in order to deny one. And that will also be there for your staff report, okay, for denial. You have to find these things. The anticipated detrimental effects cannot be substantially mitigated. This isn't just your feelings. This is This project is going to create this effect on the surrounding property that we can't mitigate. Meaning it will cause harm in some way. Or you find there's a compelling countervailing public interest that will be jeopardized. There's case law on that. Yeah.
So with the Snowbird extension, I noticed the staff recommendation was to approve it this time, but in 5 years, if they haven't figured it out, the idea is that we would deny it then.
Right.
So what is it just that we've given them so much time, they haven't moved on it, that's enough to deny?
Yes, different legal standard. For the extension, it was substantial justice. And what staff was telling you is, at some point, time or delay becomes an injustice.
Okay,
That's what they were saying. Yeah.
perfect.
That's part of what we just approved today, isn't it? That they wouldn't get another extension because they've already had extensions?
Yes. So as we were going through that, we realized there was no cap. There really needs to be a cap on things. People can't just keep coming in here, for 20 years saying they're going to do something. So we put that in there. That's a hard cap. You don't have to worry about it now. It will, as soon as that's passed, it will be law in Utah County, and they can't go beyond that. Makes decisions easier, I think. Yes, sir. Did you have something?
I agree.
Your pen was up. I just didn't know. That's it. You've been here long enough. Unless you have questions, concerns, digest all of that. We'll come back at another day.
I would just add, like with the Snowbird thing, I mean, you did have COVID, and that really did disrupt supply lines. And so hopefully there's some that's considered,
Consideration of mitigating
We felt like they
circumstances.
didn't bring that up enough. We
Yeah.
felt like that was a legitimate, substantial justice.
I mean, it was a
element
hiccup
that
on
they didn't
everybody's
really-
life, and everybody,
They
Yeah.
didn't push on it a lot.
yeah.
One of these guys brought it up. I was like, yeah, absolutely. I would have been using that a lot.
Well,
Let's
and I'm just saying, moving forward, you want to put a cap on it, but I also think we should be able to use our discretion. If there, I mean, say
Yeah.
like there's a lot happening right
Yeah.
now with the possibilities of steel getting really expensive, and what if you
Mitigating
can't
circumstances
afford,
come up again.
you're going to wait for 5 years, so maybe
Hopefully there's not another pandemic, but we used their combined 30, 40 years of experience to say, here's kind of what experience tells us we would need in caps, and tried to go out far enough that hopefully that would never happen.
And-
But we had to have a cap, because we learned with Snowbird, there's nothing in here saying they can't have it. So we have to entertain it and go through this.
We the way it's built and it existed too is those concerns need to be raised by the applicant at the time of their approval. They're saying, we rely on steel a lot, and the market's really looking sketchy, and so it's rather than the 3 years that the ordinance says, we feel comfortable with 7, and this is why. And then they still have that ability to get some more. So there is a little flexibility.
And I think the fact that now that it's in law, they know that they can't file an extension, so they got to get moving on it or make a decision. So
But theoretically, though, doesn't it just stop you from more work, though? Because if they got approved for the first conditional use, they can still go and go through the whole process again, right?
Oh, yeah.
And
Yeah.
they should theoretically
permit.
be able to get that conditional use.
Sure.
Again.
Absolutely.
So
Oh,
it's, we kind of stop the county from having to spend extra time or, because they should be able to, unless that commission was completely different than us, they should be able to get that conditional use again, but it's a lot of work for.
Yeah, that's true, but also just realize that after 8 years, our ordinance may have changed, other things may have changed, and that should go back for another review if that's the case too sometimes, so.
Surrounding properties have changed, and maybe a new commission should look at it.
Well, I applaud everybody here for the 4 people that were here, and you guys for that. I mean, I was in DC watching it on YouTube, and I was like, whoa. I mean, I know,
Karen.
but good on you. You guys
I
did
call it a
awesome.
master class in how to run a meeting. It was well done.
Wow.
Everyone involved, you all did great.
Good job. Yeah, I mean, you just come across like you really, really want to get down to the truth and make the right decision. So, good job.
No death threats.
Okay, Chair, I am done.
Okay,
Cede the floor to you.
thank you. Is there any more comment from the commission? Seeing that as there's no other business, the meeting is adjourned.